is being recorded. Welcome to the meeting of the Family, Children, and Custody Subcommittee of the Paraprofessional Program Working Group. I see that we have a few attendees. So let me give them just another moment. If there's any attendees who are interested in making public comment, please use the hand raising function in Zoom to.
Linda, do you want to start off with the roll?
Oh, okay, I can do that. Sorry. Bashan?
She just got into the waiting room or the attendee area.
Oh, okay, let me add her. Okay. Okay. Hi, Sharon. So I'm just taking roll. Bashan?
Here.
Hamilton? You're on mute, Stephen.
Sorry, present.
McRae?
Here.
Olvera?
Here.
Sarush?
I am here.
Great, so we are all here. So now I will invite public comment. If there's anyone who would like to make a comment to the working group, please indicate by raising your hand in using the Zoom function. It doesn't look like we have any interest in public comment. So I think we can go ahead and start. And I think the plan was to, the plan was to continue the discussion where we left off. And I can bring up a Word version of the document that was posted, or unless Stephen, you wanted to do like you did last time, it's up to you, whatever is easier for you. You're muted, Stephen.
Is it hard for you to translate the documents when I send them over to you?
No, not particularly.
Then I'd say for me, it's easier to go off the list than me and Fariba did, unless it's confusing to anybody when I do it.
No, I think that's fine.
Okay. All right, share screen.
Let me stop sharing. There you go.
Screen. Okay. And I'll jump ahead to the things because we had kind of summarily talked about the ones where Fariba and I had reached conclusions, and only on the second, we hadn't got to the second page yet. So the undisputed issues we'll skip over on page 1. I think what we had agreed to, but we kind of needed to make a decision on, was we had changed our position on the domestic violence based on the understanding that we're going to require for the family law certification as a paraprofessional, that there is going to be a significant domestic abuse education component, as well as a continuing CLE component. And so the idea that we were going to have court documents reviewed and approved by an attorney prior to filing, because they're going to have to, we will include either by hour or percentage, a certain amount of the experiential hours also being in the area of domestic abuse. The necessity of a certified paraprofessional to have their post-certification documents reviewed by an attorney seemed unnecessary. Is there any disagreement about that? Hearing none, that's coming out and it's gone. We had initially excluded child custody issues or disputes that would raise the presumptions under Family Code Section 3044, where there's domestic abuse allegations, and based on, again, rethinking what the training and education would require, at the brilliant suggestion of Julia Brennelson that now will have domestic abuse component, we can take this out. And that's what we had tentatively discussed last week or earlier this week. And I think where we left it was the disputed initial venue issues and not a change of venue based on subsequent circumstances, that type of venue change comes up regularly in family law. If the parties have both left the county where the action was initially filed, as a matter of course, absent someone showing good cause, the matter is going to be, venue is going to be changed. You also have the situation where if the support, actually it could be either party, but usually if the support recipient relocates to another county, the venue for the support action, if it's being handled by the commissioner, is it Title 7, Title 8, whatever it
Title
is.
40.
What is it?
40, Title 40.
Title 40, okay. So the Title 40 commissioner's doing it, then 4D is doing it, then that results in a change of venue too. What I think Fariba was addressing here was if there was a procedural or legal argument as to the initial venue where somebody filed, that should be excluded.
Steve, if I may clarify, this issue, the initial venue and jurisdiction issue is not limited to custody visitation disputes. So if we do have a do we have a general section? Because in family law, you will have a contested jurisdiction and venue, not often, but sometimes. So my suggestion is that we move it to a more general location rather than just limited to custody visitation issues. I mean, it could come up in a DCSS action. It could come up in a petition for custody and support. It could come up in an independent DV action. I mean, it could come up in any of those actions. So I think we should call it initial jurisdiction and venue disputes, and then discuss whether we want it included or excluded.
So let's put that in. I put that, Fariba, because we've got the specific area of the UCCJEA issues not being included.
And those are normally not initial. I mean, if you sometimes, depends on the type of jurisdiction we're talking about, you can waive it if you don't bring it up, if you don't object to it. So it's never going to be otherwise addressed herein, because that's like number one thing that has to be addressed. There's nothing before it, in my opinion.
Okay. I think that was a reference to these two.
No, this is fine. This is fine. That should stay.
Okay.
in my opinion.
So I think I'm okay to, maybe what I'll do for right now, those are the only, except UCCJEA. And this actually may not be relevant if we go excluded. We'll do it that way. Less cumbersome, more specific. And what do you think, Fariba?
I don't understand when you're referring to within the marital settlement agreement box, you're referring to UCCJ in Hague.
Wrong place. It's here.
Oh, okay.
Yeah, I just went the wrong way. Except
Got it. Okay.
And Hague. So.
Okay, if you want to go back up to custody visitation, this is where we left up. Okay. I think I would agree that those are everything included for custody visitation except for those two. I can't think of other issues that I would think they should be excluded.
And I would concur that including this is really important, because it's unlike other civil litigations. This is not a one-time event. There are constantly, you can have multiple pre-judgment requests for orders to get temporary orders, and people may change them. Post-judgment, until the children age out, there's going to be post-judgment requests potentially to modify. This is the area where we're really going to help create access to justice when it comes to custodial issues. So this is a no-brainer to me.
I agree.
I'm getting a nod from Dana. Thank you.
And we don't see Sharon, but Ah, there she is.
Hey, Sheriff, do you see any issue with these parameters for paraprofessionals providing services in the area of child custody and visitation?
We can't hear you, Sharon.
Sorry. I don't know if I'm having technical difficulties or if I'm the technical difficulty today.
Well, and your cameras, we couldn't see your mouth, so I couldn't tell. Were you really intently looking at the words?
Oh yeah, I'm looking. Yeah, I'm using my phone today because my internet is down. I'm looking at all this work that you two have done, and I appreciate it. I am, and I raised this last time. Well, I guess I should first say that I'm glad that you excluded the UCCJEA and Hague. I think that that's appropriate. I am just, walk me through this. And I know you sort of did last time. I'm just looking at this entire list and looking at a bunch of inclusions and then exclusions. And I think that as a practical matter, these paraprofessionals are not going to be working in an office with an attorney to where they can just refer out. So it's going to get we're going to need a lot of training because a lot of these excluded items, not necessarily in the child custody realm, but in other realms, they're going to be very embedded to what they're doing. And I don't want to incentivize any paraprofessional to maybe put something in a different category because they're allowed to do that work, but not this work. And I just think that having anything except for like bright line exclusions is going to take a system and it's going to take some training. So that's my only point so far. Does that make sense? Like, did you think through that?
I think it is. The issue or concern is that if we don't have very clear parameters, you have a concern that a paraprofessional might try to characterize a dispute in a way that allows it to be an included service as opposed to an excluded service?
Either that or just not having enough training to know, like, well, it's more advantageous to if this person applies through this excluded service and I really should refer out, just knowing exactly what those like fine lines of having to refer out look like. And having a system to do that. It's a lot harder when you're doing this day in and day out. You're going to need to have some very strong referral systems, especially if you're going to still retain some work for yourself, but then refer.
So I think that we've been facing this in subcommittees because we're gonna devise this list, then we're gonna come up with at some point the training components for this particular specialization is going to be planned. And I 100% agree with you that they have to be trained to issue spot, right? Oh, this is what they were talking about, right? So, Hague custody visitation issues, Hague service issues, what is that? So I totally agree, but I do think that that's to be discussed in this training subcommittee or whenever they design the training material. With regards to referrals, we do that here at the Suffolk Center all the time, right? So we right now, we've always referred to the local bar association lawyer referral service, and we cannot refer to specific attorneys. We do have a list of agencies that provides free services in various areas of law, so we can hand that out as well. It hasn't helped recently that our local bar association has faced financial difficulties, and one of the areas hit is their lawyer referral service. So we refer up to the state bar's lawyer referral service link, and hopefully people will find their way to an attorney. So again, I just think that we just need to focus on coming up with this list, and then giving direction to the folks who are going to come up with the training modules. That's my opinion.
I'm really glad you said that, Fariba. I'm actually not part of the licensing group, so I guess that was my second question that you reminded me of, which is this group going to give that group suggestions on exactly what the training and education is going to look like? And it sounds like we are, and gives me a lot of assurance, because I do think that we need to spell out that type of training and education.
The other thing I wanted to add is in the regulation subcommittee, is another one. There's been a lot of discussion about rules and referral fees, for example, rules around referrals is something that has come up. So I think that's another aspect in addition to training is the regulatory side and how you will decide that you want to address referrals.
So what we've done is we've used endnotes at the end of this where we had specific educational components for the family law certification where we wanted that to be included. And so it wasn't working for me. I'm gonna have to go back and do it. On this particular, the first excluded, my suggestion is we have an endnote that says to address what Sharon's raised is that the education includes issue spotting, clear definition of the excluded item, specific education regarding the excluded issues. In other words, we can't just tell them annulment based on these 5 factors are excluded. We have to tell them what it is so that they know they can't work in that if that claim comes up. And then addressing Leah's complaint point to include in there that the referral process is part of the education too. Not only having a referral network, but what the rules and regulations are. And I would assume we're going to have the same rule that attorneys do. If you're going to give a referral fee, you have to disclose that, get the client's consent, and give them the opportunity to have independent legal consultation regarding the referral fee. Sharon, does this end note that I'm proposing that I'll add in after we're done, since I'm having a numbering issue, does this work with what you were identifying?
Yeah, I'm glad that you are including that. That does make me feel better. I guess I'm just thinking really in practical terms of someone who does not have a lot of money for an attorney that has a complicated case. They go to a paraprofessional. Paraprofessional can do some of these things, can't do other things. Paraprofessional does a great job in issue spotting and tells the client, I can do these things. You're going to here's a list of referrals to the bar or to free legal aid for the things I can't do. They go to legal aid, they may not qualify. They go to the bar, they can't afford the attorney. I guess like there's an argument, at least they're getting something from the paraprofessional, but they're not getting their holistic needs met.
I totally understand that, but that doesn't mean that same argument could be made about self-help centers. We should provide help in every area because that person cannot even afford to hire a paraprofessional or a paralegal. They cannot afford anything, but we can't. Frankly, it's outside of, well, we're statutorily created and, we follow other rules as well. But I don't think that's the answer, that let someone handle these overly complex issues just because the person doesn't have any other options. Because there's certain expertise that's needed that the paraprofessionals will not have.
Right.
And checking a box and, trying to address the issue, which we see right now, which is just horrible. It's setting up people for failure because they're going to go to court by themselves and they cannot argue this thing. The paperwork is insufficient. There's no points in it. I think it's just beyond what we want them to do.
Yeah, no, I hear you. I think I'm just really thinking out loud and as much
concerns are valid. Your concerns are absolutely valid.
And I would also say that we really are focusing on, in terms of specific areas that are being excluded, they are not common or frequent issues in family court. They are the rarity, not the normal type of claim that's going to be made. And a lot of these times, I think a lot of these issues are ones where many attorneys would actually seek consultation and get another attorney experienced in that area, for example, Hague, to be able to respond. So I think the issue would exist, Sharon, even if the person was represented by an attorney.
Mhm, mhm, mhm.
Okay. So do you think that with a 3044 presumption, that with a proper education, a complicated case, either on the respondent side or on the petitioner side, that a paraprofessional that's an appropriate task for a paraprofessional
I think,
within like, a domestic violence case?
I think so, because if you actually teach the statute, there is specific, there's kind of like three basic things that always come up. When did it happen? Is there documented evidence of it? Because that's come up as an issue. And making sure they understand you don't have to have a domestic violence restraining order to raise 3044 issues. So if they're taught those three things in the course of one class or two classes, and examples are given, that's the main issue spotting on those in that area. I think I think that the judicial training on domestic abuse is at such a high level in California. I think the judicial officer is able to, once the evidence been presented to him, you typically don't bring in psychological testimony anymore about how domestic abuse affects the children. It's almost like the court's got its own inherent Brandeis brief on that issue. They know it. And so it's more of gathering the evidence, getting the police reports, subpoenaing the officers if that's necessary, or the custodian of records.
And if the paraprofessional is helping the restrained parent, the rebuttal factors are set forth in the code in such a way that, as Steve mentions, with training, the paraprofessional can learn the factors and then how to, what evidence is relevant, and just really do a good job.
Can I just jump in I'm not a committee member, but let me just jump in for 1 second. Because as I sit here listening to you, it's not the factors that concern me so much. I don't think it's that difficult to go through and instruct on what are the factors, regardless of who you're representing in the action. But as I listen to this conversation, what I keep thinking about are the rules of evidence. And I think it's one thing to say you can gather the evidence, but that's easier said than done. And that is a whole other area of training that I'm somewhat concerned about. How would the paraprofessionals really get their arms around what are the rules of evidence? What are these different buckets of materials? How do you actually obtain them? I mean, this is often a complicated issue. For example, when dealing with police reports, a lot of times it's electronic evidence. Having sat in a family court, I mean, what people often want to do is hand you their cell phone, which I will say I took on more than one occasion, and, show you like, this is the Facebook messages that were sent. Here's a photo that was posted. So I raise a little bit of a red flag around the evidentiary issues that can arise in these contexts, and the need to think about what, if any, could be adequate training and preparation for that.
I think that, we're concurrently working on the licensing and the practice areas. My expectation is, from the conversations I've had with the licensing subgroup, evidence is going to be a course that is mandatory. And even for the paraprofessionals that come from a law school background, it's not going to be theoretical. It's going to be the actual rules of evidence, and everything that you just identified, Justice Pastru, I'm expecting to be in that course, that it's going to be taught. This is how you get police records. This is how you get medical records. This is the concern about producing a party's medical records because of the patient-physician privilege. I'm expecting that to be one of the more intensive and more important courses that are part of the education.
I know that early on, we really focused more on tasks. So pleadings versus paraprofessional being able to go into court and argue on behalf of the client. And we've shifted clearly, like right now, to a lot of the substantive areas. Are we going to go back to that? Or did you and Fariba envision some of those things in these areas?
We never got through this, despite all the time we spent to get to the list of tasks. So yes, we divided our duties, if you will, to substantive issues and then tasks. So we've not even gotten to tasks yet.
Yeah.
But in discussing these substantive issues, we had to cross over to some tasks, right? Clearly. But yeah, I mean, and I think there was a crossover with discovery and evidence. That should be on the other list. And Linda probably has that list. I mean, I have it somewhere.
Yeah, we have a separate list of that. This was just the substantive areas that would come up. But that'll be part 2, I think, Sharon, is what are the areas? And I think it's going to differ by practice area. So I think it can be very family law specific. And I think that's, once we've got the substantive areas covered, that's what I expect us to cover.
I'm
But-
curious to hear from Elizabeth. I know she's here, and I don't mean to put you on the spot, but you're our only legal document assistant, and I really want to hear from you about these issues. You know, what do you think about handling rules of evidence and Hague and UCCJEA?
Well, I'm excited to hear that it's going to be a course and they're going to dig into the details of it, because in paralegal school, we don't go that deep dive into that subject. So I'm looking forward to the class. You know, I have helped people, you know, in domestic violence situations, and they have it on their phone, like Justice Petru mentioned, and I have to help them print them out, describe the situation, when was the text taken. So I can help them with that. But like you guys mentioned, we don't have the in-depth knowledge for, you know, citing rules of evidence but either way, when we help people like that at their specific direction, they're on their own once they're in the courthouse. So, yeah. Was there something specific?
So envision, you know, the new program where maybe, well, you're doing more now, right? Would you, with regards to rules of evidence, and let's just say the decision was made that you could represent them in court, and let's say you know, you could do that. We haven't gotten there yet, but how do you feel about, you know, learning rules of evidence as part of a course and being able to actually present a case following the rules of evidence, like the justice mentioned, you know, presenting text messages? What do we do with a police report? What is hearsay? You know, all that.
Yeah, I think that because it's written in the statute, it can be easily, you know, understood and explained by the teachers, and that it would be something that they would just be able to grasp, the paraprofessionals. Yeah, I don't see it as being an issue as long as everyone is clear on what it means and how that works in the legal setting. I don't see it as too out there that we can't comprehend. Yeah.
I think too is if we look at the underlying objective of increasing access to justice, one way that currently self-represented parties get hurt the most is they don't know how to get their evidence in. And it's all the family law judicial officers that I deal with will try, without going beyond the appropriate boundaries, will try to not let someone lose by default because they didn't know how to authenticate or introduce something. But when it comes to a hearsay document, they have to follow the rule. And I think that an intensive evidence course is part of the education that we're requiring, and literally taking it from the California evidence code, the rules of court, to how do you subpoena and what do you do, notices to consumer, all that process. And then how to create an exhibit binder. When do you serve it? How do you do it? Giving a self-represented party a paraprofessional's assistance in going through all those steps, I think will immensely increase their access to justice, because they're not going to be denied justice because they didn't know the rules of evidence and didn't know how to subpoena the custodian of records for the police department.
Evidence is definitely an issue for self-represented parties. I also know that when I was in law school, that was a year-long course.
I'm trying to think about. See, evidence was the year I dropped out of Hastings, so I think I got like the first semester in before I went to the law office study program.
I was talking on mute. I think that even for attorneys, rules of evidence remain a challenge. 4320 factors remain a challenge. 3044 factors remain a challenge. So I have to say that remains to be seen. But if you have a really good training module, and then the rest is up to the student, right? And that's remain the same whether you're an attorney or a paraprofessional. It's just how good of a student you are, and where's your integrity, and will you do something where you're not competent to do?
And I think we can also address it, again, like we were doing with the domestic abuse issues. If we require a percentage or amount of the hours for the experiential to specifically address these tasks within that come under the evidence area, in terms of doing subpoenas, submitting exhibit lists, preparing exhibit binders, whatever it is, we can include that as part of the experiential requirement. And we're also ultimately going to have the testing provision too, which will be far more specific than the state bar exam is on evidence. It's not going to be theory, it's going to be practice.
Let me ask you something about domestic abuse. You have a petitioner, they've had the 5-year restraining order, they're still scared. They go to a paraprofessional. Do you envision that a paraprofessional is gonna be well-versed on case law and is gonna argue that Ritchie versus Conrad case? Or is that gonna be attorney category?
No, I look, this comes from some of the work that the Family Law Violence Appellate Project has done, in terms of there doesn't have to be, it just has to be an objective, reasonable fear of future conduct, regardless of no past violations. I'm looking up my case summaries to see if that's the one that I cite when I'm dealing with this issue for renewal of a restraining.
And Sharon, you're talking about renewal of a restraining order, yeah?
Yes.
Yeah. We see self-represented litigants do it all the time on their own. And like Steve said, a minimal showing is enough to get that renewed. While I don't see every case, but on those calendars, we see that a huge majority are self-represented.
Yeah. Okay. Now I know what it is. I don't use Ritchie versus Conrad. I use Cueto versus Dozier because it came out a year later and cited Ritchie, so that's why it threw me off. But I think if you literally in one class or less, you could address the renewal issues and make sure they're aware it's an objective standard. There doesn't have to be any new acts of violence. You just have to go through the checklist that's within the renewal statute. I think yes, I guess is what I would say.
I want to ask Justice Petra if she believes that with a really good training module, that this group of professionals could be trained on something like rules of evidence.
I think it's hard. I mean, I really do. I'm not saying that it's not possible, but it's difficult. I have two counterbalancing thoughts. One is someone said something to the effect of, the vast majority, there's a very, very high percentage of self-represented people currently appearing who, of course, don't know the rules of evidence, and they'd be in a better position to have a paraprofessional assisting them. Absolutely agree. And then it's the question of course, you don't want to give people assistance that is inadequate assistance. And so I think this evidentiary, I think this issue around the rules of evidence is the most difficult one. If we think about in a regular law school evidence class, how much time is spent on the rules of evidence. This is not a small amount of time. It's something that is given a lot of attention to, understandably and appropriately in law school, and then requires quite a bit of work going forward. It's hard. People think evidence isn't hard. It's actually really hard. And so I don't want to minimize the fact of how difficult it really is. I don't want that to, waylay everything. And maybe this is a conversation more for what kind of training is required. But, to be really blunt, that's my biggest concern as I sit here listening to the conversation.
Mm-hmm, mm-hmm. And we haven't decided whether we're gonna agree to allow paraprofessionals to appear in court. So if the end result is that they're prohibited to represent someone in court, then their role is limited to coaching and legal advice and so on. If that's the case, then do you feel, sorry to put you on the spot, Your Honor, but would you envision that a paraprofessional could play a good role as a coach? And
I don't know how different it is if it's coach versus in the courtroom. If the point is that you're trying to, help people get records, figure out what is appropriate. It's easier, obviously, in a family court setting where there is no, for example, there's no jury trial, right? And so the judge is very often in the position of being both the finder. The judge always is in the position of being both the finder of fact and the, finder regarding legal issues, and therefore tends to be very adept at looking at a universe of documents and saying, like, yes, this I can consider, no, this I can't consider. I would say, for example, if we were talking about juries, like, no, I think it's much more complicated if you're talking about someone having to present a case to a jury. The reason that I'm, open to this conversation and thinking about this right now is that it is in front of a judicial officer who is used to having to, go through all of the material and sort it out. That being said, I'm just really talking off the top of my head. I wonder whether there's going to be, when you have a self-represented litigant who is appearing in front of you, they of course are held to the same rules because they are choosing to represent themselves in court. However, out of a basic sense of equity, a judicial officer will often give that person additional time, set further hearings, do things to allow someone to have more time than perhaps would be given to an attorney to get their act together and, obtain the documents and move the matter forward, right? And often there is a conversation of this is missing, go to self-help, go to somewhere, try to figure out how to get it done. I don't know how this would play out, honestly, if it were a paraprofessional representing someone in court. And I think it would be hew more towards the end of an attorney and more appropriately, towards an expectation that the ducks would have been put in a row before showing up, rather than having it be an ongoing process. And as I said, I don't even know what my point is. I'm just thinking this through and talking about it.
Mhm.
So I think there's a little bit of a difference between the representation behind the scenes versus in real life in the courtroom. But I think in either event, the paraprofessional would have to be well-trained regarding the regular issues that come up in regards to rules of evidence. I will say, I've been in the process of identifying, speaking with, and adding some new members to our group. And one person who has just agreed in the last couple of days to join us is the Honorable Monica Wiley, who is the supervising judge of family with the San Francisco Superior Court. And I think, she's been doing family there for, I'm going to probably get this wrong, but I'm going to say 8 years. And I would be very interested to know what her view is on some of the matters that we've been discussing, which is not to slow down this process, because I obviously want it to move forward. But I just wanted to let you know that there will be someone, for example, at the December 17th meeting, because I believe she's trying to clear her schedule to attend that, who might have some valuable input on the questions that are being raised.
That's significant. That's really excellent, but also significant. I think when I'm approaching this, I have my belief, like my position on family law that I'm pretty set in is I don't believe there should be in-court representation. I think it should be to help the self-represented get ready for court and to not cross the bar if they're not attorneys and not voted on yet. But I think hearing from Judge Wiley would be helpful on that, to whether she thinks it'd be more of a help or a hindrance. When we dealt with another subject matter area, the input from the judicial officers that practice in that area was really helpful. So if we know, one, it raises the question, should we decide or make a recommendation or get an opinion on that first? Say a total chicken or the egg issue, right? We want to know, like, if we're going to use whether they can appear in court or not as helping us define what practice areas are included, maybe we should know that first. But to vote on that issue, we're also going to want to know, what are we allowing them to do in court? And I don't know the answer to that.
And I'm struggling with that too, Stephen. Like, so I think it is a chicken and egg issue, and I'm trying to envision all these areas and what it's going to look like for the consumer and how we can make decisions that both protect them, open access to justice, but a process that's as seamless as possible so that they don't have to go through 5 doors just to get some basic needs met. But also, like, I know we keep on saying, well, we're going to have to decide what licensure looks like, what education is going to look like. And I'm thinking back to Washington State's program that in many ways failed because the cost was so prohibitive. So I think that we have to also be practical about what kind of hoops we're going to make paraprofessionals jump through to do some of these matters, and whether that's even feasible, or whether an area should just be left to attorneys if it's not feasible. Evidence comes to mind, for example.
I'm actually comfortable continuing discussion as we are, because I think if we ultimately decide to, for example, include court representation, we just have to talk about training. And if we don't, I still don't think they should be, if they're limited to outside of court assistance, my position still is they should not be handling Hague custody issues, for example. I mean, that's just too complicated. So to me, and that I hope helps us to go forward with our discussion. And then if we decide that they could have some role inside the courtroom, then we just talk about training and how to limit that or what that entails. That's the way I look at it.
I'm smiling because I looked up Judge Wiley. She's another bear, I noticed, but she also went to Giannini Hall because she got her degree, undergraduate degree in political economy. I was in the same building too, so that's good.
Oh.
Okay, I would just wanted to put that, when I draft this, my opinion is not yet a vote, and my vote may be on the losing side, but I'm always envisioning that there is not going to be in-court representation. Not to say that they're not going to be there to assist the person, like can they be in the courtroom and help? Absolutely. But that's always been my threshold. So some of these things that I'm saying yes to, mine might change, Fariba, is I might have a more restricted practice area if they're allowed to make in-court appearances.
And we can take that on, but for the sake of moving forward, maybe
I agree.
Just keep discussing.
Okay. So let's see, child custody visitation. So I think we're done on, I think we're as far as we're going to go on that one. True. Child custody and visitation with the added end note that I added that you'll see at the end now, Sharon, about issue spotting and making sure they understand what the excluded issues are as part of the education. Child support, we talked about last time. Temporary spousal support, I don't think we went through this category last time. I think temporary spousal support was an easy yes for me, and I think it was for you too, Fariba, because they're using the calculator. The issue was permanent spousal support, short-term marriage. We went back and forth on this, but I think ultimately we agreed, even though it's a 4320 analysis, if you're dealing with a short-term marriage, it's not as complicated if it's a long-term marriage and you're not dealing with probably the lengths of time that someone's been outside the workforce, like you would in a 15 or 20-year marriage if the husband had stayed home while the wife was working. Any thoughts on that?
I agree to include. I'm curious about long-term and if the two of you did not agree on that, or if it's green for another reason.
Further discussion, not a dispute.
Yeah, we just didn't get to it.
Yeah.
I think if 40, we just haven't discussed it. So I just.
Do you agree this part that I highlighted can come out now, Fariba, because we're including the domestic abuse education and experiential requirement? This is where if there was going to be,
Oh, I see. Yes. Okay.
the subsection's missing.
Yeah.
If it was a case where there was going to be domestic abuse, but now we've changed.
Yeah, the exceptions. Yeah.
Okay, well, if I did just delete that out.
Right.
Here was the discussion on this issue. One of the, there's the two factors that come up under Family Code section 4320. You've got whether somebody's got a criminal conviction for abuse, and then whether there's the history of domestic violence or domestic abuse in the relationship. So 4320M is the criminal conviction, and then 4320I is the documented evidence of domestic abuse. We initially thought of excluding those because we were going to exclude domestic abuse. And then again, we changed, our minds were changed after we got the comment from Julia Brennelson.
Yeah.
I think this can come out. I think
So
I'm
that's
okay.
D. So that's D. 2. So that
Right,
and
I
then D.
want, right, so. Oh, I remember, okay. This was whether,
Yeah.
do we let the thoughts on whether a paraprofessional could be trained and educated to present all of the factors under 4320?
So I think that 4320 analysis comes in for long-term support anyway. It's just for short-term marriages, there is this notion that perhaps it's easier because the short-term marriage, have to lengthen the marriage, blah, 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 versus a long-term marriage, the rights are often, there's no end date, and you're looking at a long-term marriage, and often if the mistake is made, I mean, we're looking at, a term of support that's until further order of the court. And if the recipient is advised in the wrong way, they may, waive support, or they may not make a successful argument for the amount and duration. So, but I think it's the same analysis. I mean, it's same skills. If we're going to include it, we should include it for both and just really focus on the amount of training.
This is
I think, I don't know about you, Steve. I mean, I think attorneys, I see attorneys having a hard time with this analysis too. Those who haven't done it for a long time, the newer attorneys.
Any comments or thoughts would be greatly appreciated here. This is one that we're struggling on. I think we can reduce it to a more basic question. Should a paraprofessional be allowed to address any permanent support order in light of the requirements to produce evidence under Family Code section 4320? And we're either going to, include or exclude permanent support, and there might be some specific areas that are excluded. I had identified the wrong stuff. I think this comment no longer is relevant.
Exactly.
Again, including the domestic abuse training. So D was out. I think we were, regardless of whether they're going to do the permanent support issues, any waivers, buyouts, or step downs that are non-modifiable.
So I have a comment. Instead of removing D, what if we put something like, unless that person has also received the divorce specialist training, right? So it specifies that only they are allowed to do that part.
I think that with the other states, they have the areas which they're certified. I think we're saying only the ones that receive the family law endorsement are going to be able to practice in these areas. That there's going to be a family law endorsement identifying what the education is, and if you've got the endorsement, then you can do all the tasks that are up on the chart. Let me reshare that again.
And just as a reminder, Stephen, is that endorsement an attorney signing off?
The endorsement is, you've got the family law paraprofessionals, you've got the civil law paraprofessionals, you've got the criminal law paraprofessionals. That's what we're thinking. And it doesn't stop anybody from getting multiple certifications. And I think the idea was, what we're going to probably require an education from someone that wants to do family law is probably going to be much greater than some of the other areas, because helping somebody get their felony reduced to a misdemeanor, or their misdemeanor off their record is not going to take anywhere near the amount of education required to handle these tasks for family law.
Agreed.
Do you mean certification, endorsement? Like who, you mean certification by the state bar, or endorsement as in, as practical training with an attorney and the attorney signs off on something? I'm a little confused.
Are you asking me, or are you?
Yeah,
asking-
because you keep using endorsements, the term endorsement.
Oh, okay. I guess it's my own term of art. Every paraprofessional is going to be would have to have an endorsement in at least one area where they're certified.
A specialization, like pick a specialization, right? Okay, all right. Sorry, I thought we were talking about something.
I would be very reluctant to use the term specialization, given the rules regarding the use of the term specialization for family law or for any attorney.
Okay.
So for section C, spousal support waivers, buyouts, or step downs, that's excluded. Well, I know that in a lot of the MSAs, spousal support is waived. So should there be a distinction made? And in San Francisco, if the parties, you know, they work at Facebook, the other one works at Apple, they don't want anything to do with each other, they both want to waive spousal support, there's no children, they put that in the marital settlement agreement, and San Francisco signs off on it. In Alameda, if they wanted to do that, the parties, Alameda requires more information, maybe a standalone declaration that says, this is our age, this is our health situation, we are self-supporting, this is what we make. So I just wanted to make that distinction. If we put spousal support waivers as excluded, how does that go into account with MSAs?
Can I ask you a question, Elizabeth? So in that situation where, when your scenario, when they're coming to you, you're not giving them legal advice though about the implications, correct?
Correct.
And these paraprofessionals are now offering legal advice. So it's going to be a different duty of care. It's a different threshold. I think that's why it doesn't prohibit them from still going the LDA route, but if they're going to hire a paraprofessional, this would be an area where the paraprofessional is wouldn't be authorized to offer legal advice.
And I do think it's a different situation for waivers where you're talking about a short-term marriage than a long-term marriage. So like Steve added here.
That's why I added the comment at C.
Yeah.
So if it's
but then you got the 6 months marriage and a 9 years and 7 months marriage, you know, to what extent can a paraprofessional then, you know, that still requires some legal advice about, you know, 4336 is, there's a presumption that a marriage of 10 years or shorter is a short-term marriage. So how do we rebut that presumption? Blah, 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 blah. You know, I'm getting too complicated maybe for this discussion. But you know what I mean, Steve?
Yeah, I do. That's why I sua sponte added that language. Because we wouldn't want to, I agree with you, we wouldn't want to preclude in a short-term marriage the paraprofessional from assisting them in doing that. But it's these long-term marriages, and I've seen that's probably one of the areas that most causes a set aside, other than a duty of disclosure failure. And I've really seen in some long-term marriages, particularly where the long-term marriage, there's been elements of abuse, coercive control, financial control, and a party gets talked to into terminating spousal support in a long-term marriage so that they can keep the $15,000 Buick, right? No way. And I think that's that balance between giving people another form to get legal assistance and increasing access to justice, counterbalanced by the consumer protection issues. And I see that this is one where there could be a lot of harm.
Does it help at all to talk about the value, the economics of a long-term marriage? If we had a cap and said you can work on issues that are valued less than this if it's a long-term, or is it just getting too complicated?
I thought about that. And I think the issue for me was that's a subjective evaluation until a judge says what it is, right? And you could have a situation where someone could convince themselves, oh, this doesn't meet that economic threshold. And basically, if it was a big enough financial issue, I think it would be very difficult. And I think it could create, again, because of that subjectivity, there's no finding. I guess the judge would have to make a finding, but you could go through the whole process and the judge disagrees with that finding, then all the work that the paraprofessional had done to get to that point becomes worthless because they have to go back and get an attorney now because they, in fact, were above the financial threshold.
I should also mention that, you know, for low income people, they may not have a lot of stuff and a lot of property, but, you know, sometimes what they do have is really, really important to them and they need that. So I wouldn't want to create any kind of bias in the system.
That's why when Fariba and I did this, I don't think that we didn't include any monetary thresholds. We initially thought about that and then we go, no, it's not. I think for the reason you just cited, Sharon, it wouldn't be appropriate. So is any kind of work through this? Is anybody offended by excluding the items in 2C in a permanent support order, not a temporary order, excluding spousal support waivers, buyouts, or non-modifiable step downs? And does anybody need a discussion about what those entail? No.
Well, I mean, like I'm saying, when they sign a marital settlement agreement, that's, you know, essentially permanent. But you're saying long-term marriages, right? Okay, I think that's fine. I think those are very rare. People, once they've been with someone else for 20 years, they usually stick with them. So I guess that's fine.
Oh no. So the one thing that people learned from COVID, Elizabeth, I'm seeing so many people that would have stuck it out for the kids or whatever. They got an early preview at a retirement. So I'm getting a lot of those 15 to 20-year divorces that typically I would see after retirement. But they're doing it early because they just had to spend 24/7 with each other and they decided that's not the life they wanted.
That's true.
Yeah.
Okay.
So you're okay with that one, Elizabeth?
Yeah.
You see? Okay. So then.
And I think this is a working document. I mean, we are getting new members. I'm looking forward to their comments too. So yeah. I think we could sort of.
Fariba, this isn't the law according to Fariba and Stephen?
Not anymore.
All right. What do we do about the 40? I guess
you actually came up with a good query for that. You just said it maybe 10 minutes ago.
With what?
With regards to the 4320 analysis. We just, I mean, you had suggested that let's not differentiate between long-term and short-term. It's just about the analysis.
Right. I think that this is going to become one item.
Yeah.
And the question is,
sorry, I didn't write it down.
Yeah. So whether it's a short-term or a long-term marriage, the court's required to go through all the factors under Family Code Section 4320. Should a paraprofessional be able to offer legal advice and assist a party preparing for trial, whether they get to appear with them or not, on a permanent support order that requires a 4320? All of them require 4320 analysis. And do we want to differentiate between short and long? But we think, I'm with you, Fariba, we shouldn't. It should be either they're qualified to do 4320 factors or they're not. Discussion?
Well, doesn't it also hinge upon presenting evidence sometimes?
Oh yeah.
Right.
Yeah, because you've got to, so one of the factors is, the degree to which the supported spouse took themselves out of the workplace, right? So sometimes I'm getting 10 or 15-year-old tax returns to show what the person used to make, and then what they're you can do it with a Social Security contribution history if the other side will stipulate to it becoming into evidence. But that's the type of thing where it can be evidence intensive.
Yeah. Anytime you got factors, when as Justice Petra pointed out when we were talking about 3044, it's good to have factors, but then there's issues with evidence and proper and presenting relevant evidence and so on. And nowhere is that any stronger than 4320, I think. And then because the last factor is a catch-all factor, right?
Yeah, I almost would shift this to being, hold on.
But I haven't decided if, I have to think about it. I haven't decided if the proper training, book training,
Marital standard.
professional can do a good job on this, like learning the factors. Does it have to be more than that? Like I said, I don't see a lot of lawyers that come out of law school knowing how to do this.
And the use of expert witnesses. This is an area where you're going to have the vocational expert to testify about earning capacity and, you know, sometimes historical earning capacity. You're going to have the forensic accountants in some cases. It depends on the approach for a particular, you know, the judicial officer in front of. Someone will just say the marital standard of living is based on how much money did the people earn. They may have invested it, they may have spent it on vacations, but the amount earned is what the marital standard of living is. Versus others do the, you know, will entertain complex forensic accounting testimony from somebody who's analyzed the checkbook for the last 5 years and says, this is how much they spent on vacations. This is how much they spent on food. This is how much they spent on savings. And that one, like Fariba was saying, would definitely go beyond the skill level of even a first or second year attorney. You're making me think maybe to exclude permanent, Fariba.
So one of the things I wanted to mention was a lot of these issues don't come up with pro-pers. I know I'm overgeneralizing, but you know, it really comes down to, can one person make enough to pay the spousal support? Does the other person need it, right? You know, the 4320 lists out everything that comes into consideration, but usually most people don't get to the point where they're doing the job evaluations at the court or bring in forensics for, you know, the majority of these kinds of cases. So maybe it's a little overcomplicating what people in the low income, middle income brackets really need. But I do understand, you know, there's people that, you know, work at Facebook and they have those stocks and it's hard to quantify that and all of that. I think that would be one of those cases where a paraprofessional will feel comfortable deferring it out to a, referring it out to an attorney, because that's what my thought would be on that.
So perhaps contested spousal support issues.
What do we do this? Okay, I'm going to type. I can undo any of this that I typed.
Yeah, go ahead. Keep typing. Keep
Okay,
typing.
so we're gonna
I
go.
think that when you got middle income people, lower income people, especially if they have children, after child support is calculated, it's probably not enough for spousal support, even if one party makes more than the other, right? But middle income people often may not have things, and their only issue may be spousal support, especially if one spouse has stayed home with the kids and the other spouse has worked. And now they, even in a short-term marriage, they have to become self-sufficient in half the length of the marriage. You know, that amount and duration becomes very important. So I have to think about this. I mean,
and just so everyone knows, we're not typing. This is not representative of what's going to go to the committee as a whole. It's a working amorphous document and anything subject to change. It's just so we could put something on paper to discuss and then move on. I don't want to give this any greater weight than it's due.
Let's maybe get back to this, because I think we all have to think about it a bit. And in the interest of time, maybe move on to the next category.
Okay. So as I have this tentatively put, does anybody have any objections just as part of the working document? Temporary is included, permanent is excluded in a litigated or contested matter. Spousal support waivers, buyouts, or non-modifiable step downs can are included for short-term marriages, but not long-term. Any changes, corrections, or requests? Good. Okay. This is a mouthful.
What time is it?
Oh yeah. We go to
We have 20
Monday.
minutes.
Has anybody given this particular one some specific thought where they have comments? Because it may make more sense to move to some of the quicker ones.
So again, like this is where we are sort of crossing over two tasks. So not only substantive, like this, we talked about discovery, now we're breaking it up to written discovery, and then so I can take one on. So declaration of disclosures, we have at the Santa Clara County, we have a virtual workshop on this. We have packets online. And I think that is something that most paralegals can do a really good job. And we're even now, and then we're going to have training on it. And so I think that declaration of disclosure should be included.
And I think this is something where we can actually train the paraprofessionals to do a better job than the attorneys. The initial declaration of disclosure is due within 60 days of filing or 60 days of your appearance. The final is due 45 days before trial. I would say I'm probably the only attorney in my county that actually makes two separate documents and follows those rules. I will get preliminary / final declarations of disclosure that are, by the time of trial, 1.5 years old, that have never been updated or anything. And I actually think we can help the public better than they're being served right now by giving the paraprofessionals that education as to the timing of it and what they include.
Mm-hmm.
So that's a no-brainer for me.
Mm-hmm. Take the next one.
Appraisals and valuations. So the issue here is having the paraprofessional help the people contact appraiser to appraise the home. They're going to have to be educated. Is there a need to do a historical appraisal if the home was brought into the marriage by someone, or if somebody made a contribution to pay down the mortgage on the property? Valuations would be forensic evaluations. As long as, I think the feeling is getting some help was better than no help, that a paraprofessional could at least refer people to the people that do these services. I think maybe what we could add would be that, but the party has to be the retaining party. Do you think that's necessary for Reba? No, okay.
I mean, this is just helping him reach out to a professional, right? To do these services. To me,
well,
fine. I mean, what role does the paraprofessional play here other than
just connecting them
Yeah.
and then knowing how to put it into evidence for either 4320 or the property division at trial?
now that's a separate step.
Right.
So, sorry, I'm just going to stop you right there. Walk me through this. Client comes to a paraprofessional. They don't have money. It's also a domestic violence situation, so they were not controlling the coffers or anything like that. There's money on the other side. Some of it has been hidden. There is property. There's been commingling of some funds. You need some forensics. What do you do as a paraprofessional for the client that doesn't have a lot of money in terms of getting those experts? And what are they going to do there?
I jumped down to 2 cells. We didn't have the word expert in there. I can file a motion to request attorney's fees, paraprofessional fees, or expert fees. Does that address it?
Yeah, so as long as that's
Yeah.
part of the training.
Any other questions, comments about appraisals and valuations? Okay.
I
You wanna
just think
cover?
that we need to clarify the actual task. They're not doing the appraisals and valuations, they're doing the referrals too, right? Or issue spotting that an appraisal or valuation is needed. Referrals for, okay. Okay, very nice.
That's helpful, very helpful.
I love how he's so good at that. You just say it and he writes it.
Do I drive you nuts, Leah, though, when I take over?
Me? No.
When I start driving, I feel like she's nervously sitting in my passenger seat.
Wow.
Okay.
He's just nervously clock watching is what's
Yeah.
happening. Yeah.
I get that. Let's try to do this. I'm going to jump around a little bit. I think the discovery is going to take more discussion. I think 6, the subpoenas, deposition and hearing and trial, we already discussed that in connection with presenting evidence. Including that doesn't seem an issue to me. Motions to compel not related to depositions shouldn't be an issue. Legal assistants and paralegals are doing that already. Elizabeth, you filed motions to compel before, haven't you? Or
I have,
drafted them?
with the guidance of the Sacramento Law Library, samples available to pro pers.
Yeah, which are phenomenal, by the way. That's like almost part of the teaching curriculum. I'm going to skip over motions to compel and quash related to depositions. Post-division transfer documents. The paraprofessional can help wife get husband to sign the DMV registration or transfer form. Doing the interspousal transfer deeds. Those are done by my staff all the time. I generally don't prepare those. The one exception would be the qualified domestic relations order, which we said absolutely had to be excluded from paraprofessionals. And I think we kind of have a unanimous consensus on that. On those that I just went through quickly, is there any disagreement about how they've been designated, included or excluded?
And just when we were discussing it, my concern was I haven't done discovery in 22 years. So, it's not my expertise at all. But I was just wondering if, with not with form interrogatories, with other special interrogatories and requests for admissions and so on, it's really important that the questions are devised really well. And I was a little concerned as to whether the paraprofessional could be trained to do that. And then Steve was telling me that the others usually people copy each other's work. I mean, could you explain your answer that you gave to me?
Yeah. So 9 times out of 10, like I keep seeing my own interrogatories and documents requests sent back to me because people are copying my work. The other thing is, even if it's financial discovery, as long as we teach them, there we go. All right, this is going to be in every single law library.
Order that.
Okay? So there are, with the models that are out there, between Bender's Forms of Discovery, Rudder Group, and CEB, as long as the education and the experiential includes a training, like everything that we've included has to be included in the educational component. Almost everything we've included probably has to be included in the experiential. Mm-hmm. And so I'm expecting that we're going to have very specific criteria for those things on family law. So my feeling was on the written discovery, again, it's my staff that's generating them. I'm proofreading them. And at this point, my legal assistant does it 99% correct the first run through. And she's using the models that are available, mm-hmm. which would be available to paraprofessionals. So that's why I was not opposed to including that task. And I flip it to Elizabeth. I know you send out form interrogatories, right?
There's a judicial counsel form for it. You just check the boxes.
Yeah.
I personally don't do written discovery. If the client requests that, it's not a service I offer. But I know that LDAs do that.
Okay. So if anything, they're already getting that assistance from a non-paraprofessional. Let's up the standards for them to do it. So
I would just say keep this a working document. I really would love to hear from Judge Monica. Was it Wiley? I'm sorry, I forget the last name. And of course, Justice Petrel. I don't know if she's with us still, but I'm still not really sure. But again, that's because I don't do this work. So
I'll say that I'm struggling with this. So I would like to hear from more people, just in terms of discovery. I'm not so concerned about copying because it's more of a form over function issue. It's like, yes, you can open a Rudder guide. You can copy Steve Hamilton's, work. It's just a matter of any of the nuances that come in and knowing, I'm not articulating myself well. Like it's not the copying issue. It's more of the issue spotting and knowing exactly when to copy and how.
Yeah, and I think some of these, the written discovery has limits, right? Like you can only serve 35 in a certain case. So I wouldn't want someone to like not reserve a right or not ask for something because of that
And
limit.
I hear from our research attorneys that work for our family law judges that motions to compel are the number one motions that attorneys can't do. Attorneys can't even do a good job because it's highly technical. And I don't know if it's just limited to ones related to deposition or all motions to compel discovery. It's highly technical, there are elements and they're just not doing a good job. So again, that's why I'm sort of wanted to say, if we could keep this a working document and give especially this area and just, have some more discussion at future meetings.
So
Linda,
Ray,
is this the last meeting of this group before the 17th?
Before the 17th, yeah.
Yeah, okay, because we do have on the agenda for the 17th, just sort of generic update from the Family Law Subcommittee. I think it would be helpful if you want to tee up this particular issue for substantive discussion, we could draft the memo accordingly so that people can really be thinking about it and we could focus the conversation there. So just a thought.
I think that's a great idea. I mean, we need comments on the whole thing, but specifically, I would say the 4320 analysis and then discovery. I think those are the two areas of everything that we've discussed so far that we struggle with rules of evidence and representation.
so what I'm doing, I'm using the highlighted to literally tee up the. So Fariba, you want this discussed. Okay, then we come down to here. So basically, I think anything that's not highlighted, we're there. The question is, do we include a tentative lien or do I just take out and make it nothing, that we want discussion before we even get to a tentative position?
So you think to remove our position, not to make this leading to.
Because we're not there yet. We're not.
I think you're right. I think, well, declaration of disclosure, we are. Form interrogatories, we are. Referrals to expert. I think you should add form interrogatories in that.
So JCF, judicial counsel form versus non-judicial counsel.
Oh, judicial counsel form? Okay.
Yeah.
Can I make a comment about the quadro? The final document is signed by a judge and the final distribution is approved by the plan administrator. So I'm not really sure why we would exclude a paraprofessional updating the template provided by the retirement plan, filling in blanks. That's going to be approved by the plan administrator. And also there's third-party agencies like Moon, Schwartz, and Madden who offer this service without, the client fills out an intake form, they pay $650 and they get back a quadro that they can submit to the court. So I'm not sure excluding it is necessary. And LDAs are preparing this service. And also it's a federal, document governed by federal law, ERISA.
Or some.
I think for me, the issue is, so I've got two anecdotal stories. I'll try to be quick. I've got a client who came to me after her quadro was done. It was done incorrectly, and I have to tell her I don't think it was done correctly. And that was a situation where there was not an attorney advice coming in. Second one is 2 marriages, and even the quadro attorney expert didn't recognize that the denominator was being inflated, which decreased my client's interest in the quadro because he was still including the years that had been awarded to spouse number 1. It's such a complicated area. You have even most family law attorneys refer it out. I think, and again, with the ideas as a starting point, exclude it. Maybe it gets added down the road, but that's why anytime where my consumer protection whistle or bells go off, Elizabeth, that's where I tend to go, don't include it, at least in the first pass.
But Elizabeth, you mentioned this firm. Is that a legal firm or they're not lawyers?
They're lawyers.
Oh, they're lawyers.
Well, I'm not really sure. I'm not really sure. Moon, Schwartz, and Madden.
Right now.
Okay.
I think it's a law firm.
Yeah.
Oh, wait a minute. They're a consulting firm, but they have lawyers in-house.
Moon Charge, is that what it's called?
Moon, Madden, and Schwartz.
Oh, Moon, not it. Okay.
Yeah. I mean, this is such a highly specialized area of law. I mean, there's a group, they call themselves the Quadrones because it's that small and elite of a group.
Same.
It's,
One of those guys, sorry.
yeah,
One of the guys spinned out of that. I don't know if he's still working with them, but he created Quadro Council, and now it's a online fill in the blanks. And again, the retirement plans are the ones who have the template, so it's not like it's the paraprofessional analyzing. But even I refer it out to a attorney who prepares it. That's what I do. But I know people are doing it, so I just wanted to mention that. I'm not, it doesn't matter to me one way or the other whether it goes forward, but I just want to speak for the people who are not here in the room, that it's something that's being prepared by non-attorneys.
and I think the template's really good because it includes every employer or plan's template includes the language that's mandatory under the federal statutes to make sure that the transfer of the asset from the employed spouse to the non-employed spouse is not a non-taxable event. That's most of what the template accomplishes. And also protecting them that they're not giving any greater rights to the non-employee spouse. But the issue that I identified is making sure that the time roll calculation is accurate, gets botched all the time. And I think, you know, I have significant concerns.
It's right, like neither of these valuation experts is a lawyer on this website. And it says, we are not a law firm and cannot provide legal advice of any kind to our clients.
I think they're skating.
Yeah,
You're gonna get off and make a phone call to Office of OCTC.
Yeah.
Because they are giving, when they approve of a quadro and say that this
That's
is
legal advice. There's
that's
no
legal.
Well, there's all kinds of issues around that. But I'm just saying, it's just interesting if our position is a lawyer has to do it, but in the current market, it's clear that non-lawyers are doing it.
Yeah, but there, I mean, just the, devil's advocate for one moment on that one, Lee, I mean, as has been discussed, this is a very specialized area where actually people tend to have a lot of accounting and other expertise. And so I don't think it's appropriate necessarily to include in this. And I think the vast majority of family law attorneys wouldn't do it themselves either.
That's right.
I think under no circumstance am I going to vote for including quadros for paraprofessionals. When you have attorneys that are referring out and like the justice said, it's such a highly specialized area, like no way.
We're actually saving the paraprofessionals here. My wife is my office manager. And the one thing that I started doing that we regretted immediately stopped was doing quadros. They have the most intensive amount of complaints, issues. We're actually saving the paraprofessionals from a huge headache by saying they can't do it. May not be recognized that I'm just saying I don't want to use inappropriate language. It is a major inconvenience, hassle, and causes the most issues with clients is my observation in terms of the things that are like financial transactions that you have to effectuate for your client.
And maybe we can add them to section 2, referrals to experts or quadro professionals for maybe incorporated in that. Just we're allowed to refer it out.
But I think that, hang on, I think that any area that's included, I mean, you can refer to, we're not talking about fee sharing here. We're just talking about referring. We want you to refer it out, even for areas that are included. If you feel like referring them out, refer them out. I don't think we have to delineate here. I think up there we were just talking about appraisals and valuations specifically.
But I think it's helpful to like if someone's reading the law and say, am I allowed to do this, yes or no? And then they see the word quadro, I'm only allowed to refer out.
Well, it says excluded.
Okay.
Again, I think that if you're going to start, if we're going to start saying this can be referred out, we're going to have to do it for everyone. That's just my opinion.
Okay.
Elizabeth, what if we did this?
Yeah, that sounds good.
Help or not?
No, that's fine.
Okay.
Thank you.
Very, very quick, because I know that we need to go very soon. Last time we had experts that spoke about conservatorship and elder abuse. Are we going to have time to discuss that before our next meeting?
I'm trying to remember if we've even got that.
Let's see, what did we?
So I don't think we have that on this particular task list, because it was that, it's
Yeah.
kind of like a sub-entity in itself.
Yeah.
It was the violence, the new, I think, called violence prevention.
That's its own specialty, yeah.
Mhm.
No, you're talking about, what happened at the end of our session where we talked about conservatorships and, conservatorships? Did we make decisions or no? And
We did
elder-
not,
No.
we did not make decisions.
okay.
I'll be honest, I don't have any greater clarity yet.
Yeah. Hey, quick request, if you would, Steve. I think JCF versus non-JCF, I know what you mean, but I don't think it's, I think just call it form interrogatories. I think they're known as form interrogatories, right?
Sharon, I mean, it's almost 1 now. We could try to schedule one more meeting before the 17th, maybe half an hour or 45 minutes, just to focus on that issue, to come back to it before the 17th.
Yes, because I feel like we don't have closure on that. So like maybe 45 minutes would be great.
Okay.
And unfortunately, if I don't know if my trial is going to go out, but I'm set for a trial that week, and I was unable to attend so far. So I won't be at the meeting on the 17th unless the trial goes away.
And Steve, I emailed that we left out petitions for custody and support as case types. Did we add that already?
Wait a second.
And the only issues, I mean, all the rules that we've come up with here in terms of including, excluding, will be applied, because the only issues are child support and custody visitation, with the possible jurisdiction venue issues that may come up.
Right.
So we would just have to talk about case type, not issue. I think you just create a new case type. Like you know how we have summary dissolutions? You would just put petitions for custody and support. And what is that statement you put, including any exclusions herein, and something like, remember the statement you put in?
Yeah.
I can find my email.
So if we want to have another meeting prior to the 17th, the agenda would need to be posted today.
Wow.
So we would need to figure out a date, like very quickly.
And that would mean the meeting would have to be like the 14th, 15th, or 16th.
Exactly.
And
Yeah.
the 15th and 16th are the days that trial starts. 14th.
But maybe you can send out a doodle poll right after this call, Linda.
I will do that.
And if it's not possible, it's not possible.
Okay.
I'm also going to put guardianships in the parking lot, because we discussed it early on, but I don't remember where we landed on that and if we need to have further conversations.
I think we were guardians of the person, yes. Guardian of the estate, no. Was my recollection.
Yeah. And the only other case step is an independent petition to set aside a VDOP. I had put that in my email, whether we need to kind of create a item for that too.
Do you want to have another session together for Reba?
We could,
All right.
but that's the only other item I have.
Okay.
So,
I'll need your help updated.
and Stephen, you'll send me the revised, your notes from today's meeting, so I can have that as I'm drafting the memo.
As soon as I want. Do you want WordPerfect? You want me to converting to Words a Mess or PDF?
WordPerfect is better than a PDF. That'd
Okay.
be helpful. Thank you.
Okay.
Right.
Okay, great. I will send that doodle poll very shortly.
Thank
Thanks,
you.
everyone.
Thank you.
And have a good weekend.
Thank you.
Thanks.
Bye, thanks, everybody.
Thank
Bye.
you.